The case I want to talk about today is Holguin-Hernandez versus United States, which was decided by the Supreme Court in February of 2020. Like Davis versus United States, this is not a case that you've read about in the newspapers or magazines. But in my own appellate practice, this is actually the case that I've cited more than any other case decided this term. The story of Holguin-Hernandez is the story that begins in 2005 with Booker versus United States, where the Supreme Court struck the mandatory guidelines and in doing so imposed a reasonableness review of the length of the sentences as well as the balancing of the statutory sentencing factors. This is sometimes described as an abuse of discretion review, but in court parlance, we refer to it as substantive reasonableness review. Now, what Federal Rule of Criminal Procedure 51B says is in order to preserve an objection for appellate review, you have to first object, and then second, you have to tell the court what direction you wish it to take. So imagine a federal public defender, for example, at a sentencing hearing. Their defendant has been convicted either by guilty plea or at a jury trial, and this attorney, the defense attorney, files a motion for downward variance. Then on top of that, the defense attorney files a sentencing memorandum asking for a specific sentence. Let's say the guidelines are run up to 120 months, and this particular defense attorney argues under the 3553A factors that the sentence should instead be 80 months. Anything more than that would be greater than necessary to serve the sentencing goals. Then, at the time the district court imposes the sentence, which turns out to be 120 months, the defense attorney says nothing because the defense attorney has already asked for a downward variance and a specific sentence below that. In some circuits, particularly the Fifth Circuit, that would not be enough to preserve an objection to the length of the sentence or the balancing of the statutory sentencing factors, even though all the way up to that point the defense attorney had been talking about the length of the sentence and had been talking about the statutory sentencing factors. In other circuits, courts have held that that's enough, that an objection to the substantive reasonableness of a sentence has been made, therefore preserved for a reasonableness review or abuse of discretion review, whenever the defense attorney asks for a specific sentence or a sentence below the applicable guidelines range. This created a circuit split, where the Fifth Circuit was saying that you have to make a formal objection at the time the sentence is imposed in order to avoid plain error review of a substantive reasonableness claim. This went to the United States Supreme Court. The Supreme Court looked at Federal Rule 51B, examined the circuit split, and ultimately concluded that an objection is properly preserved so long as the defense attorney asks for a specific sentence contrary to what the district court actually imposed, even if the defense attorney did not lodge a formal objection at the time the sentence was imposed. That's Holguin-Hernandez versus United States, and it's a very important case for standards of review and for federal criminal defense generally.